Good morning, ladies and gentlemen. We'll begin this County Planning Commission meeting this morning with the Pledge of Allegiance. If you'd all please stand. Repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Would you clerk call the roll, please?
See if I can do this right. Commissioner McGee.
Here.
Commissioner Dukas.
Here.
Commissioner Rodriguez.
Here.
Commissioner Onstadt.
Here.
Commissioner Wessner.
Present.
Okay, item 4, this is the time for public comments set aside for comments by citizens on matters not on the hearing agenda for today. I don't have any cards other than the items we have here today. Staff, anything? Okay, we need to shuffle, because of scheduling issues, we have to shuffle the agenda just slightly, and we've been asked to take item 6, PL 13-0106, out of order ahead of 5. And so that's what we would like to do this morning. What is the Commission's feelings on that? Okay, fine. That's what we'll do then.
Mr. Chair, if I could real quick. Has staff had any notification that any of the parties for the other matter was being delayed or would have in other words, is somebody thinking they're going to come here and because we've changed the agenda would not have an opportunity to appear? Are you aware of anyone?
Becky?
No comments, okay.
Okay. All right, thank you.
Okay, let's go with item number 6, PL 13-0106. Applicant United Water Conservation District. Staff.
Good morning, Chair Rodriguez and members of the Planning Commission and County Council. I'm Becky Linder, and I'm here to present the staff report for conditional use permit PL 13-0106, United Water Conservation District Maintenance Facility. The proposed project is located in the county unincorporated area between the city of San Buenaventura and the city of Camarillo. It is located northeast of the intersection of Los Angeles Avenue and Vineyard Avenue in Saticoy. In this aerial photo, you can see that the general plan designation for the project area is open space, and the zoning designation for the site is open space, 80-acre, lot size minimum, MRP, which is Mineral Resource Protection Zone. The surrounding land uses are primarily agricultural and open space. The project site is located adjacent to the Saticoy spreading grounds, which you'll see in the front of the slide in this area right here, which are large recharge basins used to capture and infiltrate surface water from the Santa Clara River into the Oxnard Forebay groundwater basin. I want to go back to that slide. I just put arrows up there so you can see where on the parcel the actual project site is located up here, and then a little close-up of the area right in there. This little L-shaped thing is a easement, I believe, for Southern California Gas, or Edison. The applicant requests that a CUP be granted to authorize the continued operation and expansion of an existing vehicle storage yard and maintenance facility for their Saticoy operations for a period of 20 years. The existing shop building and associated structures are legal non-conforming uses that were constructed prior to the current requirement for a conditional use permit. The following structures are highlighted in yellow. Following existing structures are highlighted in yellow include the existing 1,700 square foot maintenance shop, which is, which is right there, it's A, and the employee break work building, which is right there, B, a 4,000 square foot equipment parking and storage canopy, which is right here as D, field tool and work storage unit, tool shed, storage container, a 10,000 gallon domestic water tank and distribution system, and 2 500 gallon fuel tanks are all existing on the site and are highlighted in yellow. The requested permit would authorize the following: removal of the existing 1,700 square foot maintenance building and the single-story employee break room building, which the existing structures are again highlighted in yellow and the proposed structures are highlighted in purple. The construction of the 4,400 square foot maintenance shop building with an interior office, and it'll have an attached canopy, is shown in purple, the large structure A, and construction of one 80,000 gallon water tank for firefighting, fire distribution with piping to the project structures is down here, the round structure, number 12. They will continue to use the existing vehicle cover structure, the workshop storage shed, storage container, the domestic water tank, and the 2 above ground fuel tanks, which are highlighted in yellow up here. Security will be continued or will be provided by perimeter chain link fencing. Water will continue to be provided by private well, and domestic wastewater discharge will be disposed through an on-site private septic system. Access to the site is provided by a private 30-foot wide asphalt driveway connected to, gated driveway connected to Los Angeles Avenue. This slide shows the entrance gate to the service yard facility, maintenance entrance. This is the existing single-story break room building to be removed and replaced by the new warehouse shop building. This is the existing maintenance shop building, which will be removed and replaced with the new 4,440 square foot maintenance shop building with an interior office. This is another slide showing the maintenance shop and the adjacent vehicle cover structure. And this slide shows the existing vehicle cover structure and security fencing that will remain. And the existing maintenance shop is located to the left of the photo. Just perspective. This slide shows the existing workshop storage shed and the storage container. And those are existing and will remain. And then the existing trailer there will be removed. This slide shows the existing domestic water tank, which will remain, and the trailer is to be removed. This is the slide of the existing above-ground fuel tanks that will also remain. So now I'm going to move on to CEQA. The proposed project involves the continued use and an expansion of an existing public utility facility. There would be no substantial change in use with the new building. The Section 15301 of CEQA guidelines exempts projects that consist of permitting or leasing of existing private facilities involving little or no expansion beyond that existing at the time of the lead agency's determination. Section 15303 exempts projects that consist of construction of limited numbers of new small structures allowed on a legal parcel. Therefore, the proposed project is exempt under Sections 15301 and 15303 of the CEQA guidelines. The proposed project is consistent with all applicable general plan policies. You may see Section C of your staff report for the applicable general plan policies and consistency findings. The proposed project is found to be compatible with adjacent land uses. No public comments or complaints have been received. It is consistent with the general plan policies, and it conforms with the Ventura County Non-Coastal Zoning Ordinance. Therefore, all required findings can be made, and you can see the staff report, Section E, for more information. Staff recommended actions are shown on this slide. I won't read them. They can be found in the staff report, Section G. To summarize, the Planning Division recommends that your commission certify your review and consideration of this item, find this project categorically exempt from CEQA, make the required findings to grant the CUP, grant the CUP subject to conditions of approval, and specify that the Planning Division be the custodian of record. That concludes my presentation. The applicant and project manager, Craig Morgan from United Water Conservation District, and Mike Ellis, Operations and Facility Manager, are present today to answer questions your commission may have. Are there any questions for staff?
Yeah, I have a couple,
Commissioners.
Mr. Chair. Did I get this right? The only CUP that's expired was for the caretaker's mobile home?
That's correct.
Was that the trailer that was in the picture?
No,
That's some-
the little trailer? No, I believe that mobile home has since been removed.
Okay. So the fuel filling station they had there, has that been subject to any new coating or anything like that?
I'd have to check in the conditions of approval.
I mean, it looked pretty old, so I'm wondering.
I can check.
Mr. Chair, Commissioner McGee, any kind of a fuel facility like that is operated on a year-to-year basis by permits from the APCD. So if it's not up to code, they wouldn't get the permit. So those are fuel filling stations are under constant review. So they would be required to upgrade them if they need to.
Yeah.
And the issue is there was a permit that expired, but then the entire facility became under a CUP requirement after it was built. And so that's why we're here today, because when it was built, there was no CUP requirement for such a public works facility or
And the
public utility
expansion.
facility.
Yeah, and because of the expansion requested.
I noticed that thank you, that the employee break room building is being demolished. Looked like a really big building for breaks, but there's no new building, so they're just going to break
It's gonna
somewhere
be-
else, or
It'll be included inside of
the maintenance?
maintenance
That's what I
facility,
thought.
because, yeah, that
Okay.
one was approximately 1,400 square feet, the employee break room building, and then the new building encompasses everything: break room, office, maintenance shop, everything together, and 4,440 square feet. It's a
Okay,
pretty good size
that
building.
makes sense.
Yeah.
Thank you.
Yes.
Other questions? Before we go further, I think this is probably an appropriate time for disclosure. Commissioner Maggie.
No disclosures.
Commissioner Dugas,
I have no disclosures.
Commissioner Westman.
I drove by it, but I did not look. This morning.
Commissioner Osgood. No disclosures. And I have no disclosures. I'm assuming there's nobody here to speak in opposition. Do we want to, we have questions of United staff from the commission? Okay, that said, then we'll go ahead and close
Thank
the
you.
public hearing. Comments? Have a motion?
Mr. Chair,
Discussion?
I'll move that we approve Section G, pages 10 and 11, the staff report, recommended actions.
Second.
A motion and a second. Let's go ahead and vote.
That's right.
The motion carries. I think that concludes this item.
I think that was a record.
Yeah. Okay, we'll go back, excuse me. We'll go back and we go to item 5 on the agenda, LU 12-0016. Report from staff.
Excuse me, before you start, I had a great deal of difficulty understanding the factual situation on the ground, what we see, okay? If you
Okay.
could take some time to explain what actually exists now.
Certainly. I
Thank
hope
you.
that I do that in my presentation. I'd like to just run through my presentation, and then if you have questions at the end, I can definitely make sure you understand
Thank
what's
you.
exactly existing on the ground. Thank you. Good morning, Chair Rodriguez, members of the Commission. I'm Michelle Gluckert-Deanna of Planning Division staff, and today I will be presenting to you an appeal of the Planning Director's decision to deny Coastal Plan Development Permit LU 120018. The project site is located in the North Coast within the community of Muscle Shoals off Highway 101 north of Ventura, just south of La Conchita. The site address is 6766 Breakers Way. The applicant is requesting a minor modification to PD Permit 1016 to construct a concrete cap which will be cantilevered between 6 concrete wing supports abutting the northern property line. The project also includes 13 linear feet of new 6-foot-tall fencing and a door to be installed at the eastern edge of the concrete cap. The appellant is requesting an opportunity to modify the site plan to allow the railing of the existing Cranston deck to remain in place over the property line, and they're also requesting that the Planning Commission adopt a resolution of intent to amend the coastal zoning ordinance. The site plan and the other associated plans are included in the staff report as Exhibit 3. I chose for this presentation just to include a section view to show the proposed project. This view shows that the proposal is to construct a 1-foot 9-inch concrete cap just within the property line of the Kelly property at 6766 Breakers Way. The project essentially serves as an extension of the raised concrete walkway on the Cranston property. The structure that you see on the screen in this section view at 6768 Breakers Way, which is the Cranston property, that structure is a single-family dwelling, and that exists. It was approved and it's been constructed, and the raised walkway on the Cranston side of the property line is also existing. A planning director hearing was held on July 25th, 2013. The planning director denied the proposed project on September 3rd, and the appeal of that decision was submitted on September 11th. So the appellant's request is twofold. First, the appellant requests an opportunity to modify the site plan based on the statement that was made by Mr. Ken High at the planning director hearing on July 25th. The appellant wishes to modify the site plan to allow the existing railing on the Cranston deck to remain in place over the property line. So the deck, the raised concrete walkway on the Cranston side is existing, and currently the railing for that deck extends approximately 3 inches over the property line onto the Kelly side. The applicant has had many opportunities to revise the application and the project description to make it consistent with the coastal zoning ordinance. The applicant has also had the opportunity to withdraw the project application. To date, the applicant has neither withdrawn the project nor have they applied to the planning division to allow for Cranston's railing to extend over the property line. Second, the appellant requests that the Planning Commission adopt a resolution of intent to amend the coastal zoning ordinance to remove the prohibition of decks in the side yard setback pursuant to Ventura County Coastal Zoning Ordinance 8184-2.1b. As we stated in the staff report, the Planning Division currently does not have such an amendment on our list of current and upcoming long-range planning projects. We have not received direction or funding from the Board of Supervisors to process such an amendment, and we have not received a privately initiated application for such an amendment. A revision of the coastal zoning ordinance is not the project that's before your commission today. The proposed project is the request to construct a concrete cap with wing supports. As we outlined in the staff report, planning staff has determined that 3 of the 5 required CUP findings cannot be made. The Planning Commission must make all of these findings in order to grant a CUP pursuant to Section 8181-3.5 of the Ventura County Coastal Zoning Ordinance. I listed the 3 CUP findings which cannot be made on this slide, and I'd like to go through each one very briefly to explain our position on each of those. Regarding CUP finding number 1, the proposed project has been found to be inconsistent with Coastal Act policies 30251 and 30253, as well as Coastal Area Plan North Coast Hazard Policies 2 and 3. Additionally, the proposed project does not comply with the front, side, or rear setback requirements of the Coastal Zoning Ordinance. When the Cranston House was approved by the Planning Division back in 2008, the Planning Division erred. We approved a set of plans that showed a walkway at the ground level of the dwelling as opposed to following grade. This was a mistake. We've recognized that mistake. We've explained that mistake to the appellant and the applicant. However, the fact that we did make a mistake on that set of plans back in 2008 does not give us cause to perpetuate that mistake. And still, the fact that the Coastal Zoning Ordinance may have been misinterpreted while evaluating prior projects does not justify repeating that misinterpretation of the Coastal Zoning Ordinance for this project or moving forward. Regarding CUP finding number 2, on page 2 of the appellant's letter, which is Exhibit 6 in your staff report packet, it states that one of the benefits of the proposed project is that Cranston can widen his walkway by moving the railing. If Cranston is moving the railing on his property and widening the walkway, then the appellant is essentially requesting that the county recognize the exclusive easement. The easement is there's an easement that was explained in your staff report. I'd be happy to go over it during my presentation if you have questions about it. But the easement essentially is a private matter between the 2 neighbors. The county does not recognize the private easement. We recognize the lot lines that are part of the lot lines of the subject parcels that are involved. To date, there has been no request for a lot line adjustment. So the issue here is that the proposed project does not conform to the setbacks that are required in the Coastal Zoning Ordinance. And by allowing such an intrusion into the side setback, we feel that that would not be compatible with surrounding development in the neighborhood. Regarding condition or CUP finding number 5, the appellant has stated that the intended use of the proposed structure is to widen the deck on the Cranston property. A gap will be required between the 2 structures to allow for geologic stability and seismic movement. Planning Division staff met with our resident plan check engineer in the Building and Safety Division to discuss the proposed half-inch gap that was submitted on the project plans. And although those plans have not formally been submitted to the Building and Safety Division, we're made aware that the architect for the project, Mr. Larry Graves, did meet with the plan check engineer at the building counter to discuss the half-inch gap. What we understand from the Building and Safety Division is that the ultimate size of the gap between the two structures will be determined by Building and Safety, and it must meet the structural separation requirements of the building code. And although the exact size of the gap is not known for sure, it is expected, based on the information that we have right now, that the gap will be closer to 3 inches and not the half inch that is proposed. And so therefore, the required size of this gap may interfere with the safety of the intended use of the proposed project. Just wanted to state for the record that today's hearing was properly noticed. We published a legal notice in the Ventura County Star, mailed a notice to property owners within a 300-foot radius of the project site, as well as residents within 100 feet. An email notification was sent to everyone on the interested parties list that included all those who attended the planning director hearing back in July, and the agenda and the staff report were posted on the Planning Division website a week ago. The Planning Division recommends that your commission take the actions that are listed in Section H of the staff report, which include to certify your review and consideration of this item, to find that the project is exempt from CEQA, to deny appeal LU 120018, to deny minor modification to coastal PD permit PD 1016, and to specify that the clerk of the Planning Commission be the custodian of the record. Mr. Ken High is here to speak on behalf of the appellant, and Mr. John Kelly is here today to speak on behalf of the applicant. This concludes my presentation. I'm certainly available for questions, and I'd be happy to discuss more of what is existing on the ground if there are still any questions about that.
Questions?
Yeah, Mr. Chair, I got a question.
Excuse me, disclosures, correct?
Oh, disclosures. No disclosures?
I have no disclosures.
No disclosures.
I need to disclose, I was in the offices of Mr. High a couple of weeks ago, met with him in his lobby while waiting at a conference with another attorney. He spoke briefly about this project and would be coming before the board. There was no explanation of factual circumstances, so I just got a general overview that this was coming our way.
And I have no disclosures. Questions of staff?
Yeah. You know, I had a kind of hard time understanding what this looked like, too, in terms of what is there now and what's the plan. This current deck, had there not been this mistake, that deck in its current format would not have been approved. Is that true?
Correct.
Okay. So we're talking inches here, right?
The proposal is for 1 foot 9 inch concrete cap,
Right.
so just under 2 feet. And the
that-
existing railing that was put on the end of the concrete walkway that exists on the property, that extends approximately 3 inches over the property line.
So if that last 3 inches, if that wasn't part of the project, then we might not be having a conversation here, or?
Well, the proposal is coming from the Kelly property, and they are proposing a concrete cap that's 1 foot 9 inches on their property.
Oh, no.
Commissioner Chair, sorry to interrupt, Commissioner McGee.
Up
I
the
think
way.
it might be helpful if, Ms. Deanna, if you could go back to the slide that showed the cross-section of the deck, just so we're all clear, because it is a very confusing set of facts. This is an unusual situation to have, an easement on the adjacent property, have that property owner come in and apply to it. So perhaps you could walk through this once again, and then you might need to go back to the previous slide, which shows the aerial, just to demonstrate, okay, where the Cranston's property is in relation to the Kellys.
Sure, I'd be happy to. I'll start with the aerial photo. So So the property that you see on your screen that's outlined in the black and white dashed line, that is the Kelly property. That's the subject property. So that's the applicant. They're the ones who proposed the concrete cap on their property. The house that is, it looks white up here in the photograph that appears to be just north of the property, that is the Cranston property. And that house that you see in that aerial photo is the house that was approved and constructed based on the set of plans for the single-family dwelling that the Planning Division approved back in 2008. So the proposal, then I'll go back to the section view. So on the left-hand side of the screen, this is showing the Cranston property, and the section shows the building wall and the floor of the structure, and then the 3-foot side setback on the Cranston side of the property with a raised walkway. And it's difficult to read on this set of plans, but it says existing concrete walk.
How wide is that, 22 inches or something?
It stays with the first floor of the structure, so there's less of a gap between grade and the walkway on the Breakers Way side than there is as it extends down toward the ocean side. The lot slopes significantly down towards the ocean. So what you can see on this is a raised concrete walk with a railing, and the railing on this set of plans is similar to what we approved on the railing on the Cranston side. On this view right now is similar to what we approved back in 2008, showing the railing set in from the property line. What's existing now is the railing is actually on the Kelly side of the property line, and it extends past the concrete walk approximately 3 inches. So there was a building permit issued for this, a final inspection was conducted, and then it was brought to the Planning Division and Building and Safety's attention that this railing does exist over the property line. So that final inspection actually has been rescinded on the property, and Building and Safety is waiting on this process to unfold to determine whether they will go back and require the railing to be put back on the Cranston side, or if it can possibly remain or be moved.
And so this 1 foot 9 inches, that's basically all on the Kelly side,
Correct.
except maybe for this gap of whatever?
Correct, exactly.
Okay, I think I got it.
Glad you do.
Any other questions?
No.
Staff?
I'll defer it till after we hear.
Okay. We'll go ahead and open the public hearing then. And I have cards from Ken High, John Kelly, and Steve Bennett. And unless there's a reason, other than that, I'll take them in that order.
Good morning, Mr. Chairman. My name is Ken High. I'm an attorney, and I represent Brian Cranston. Before I start, I would like to bring you some photographs that show the property. The first one, which is omitted, I folded it over. That's just an aerial photograph. You've already seen that. The photographs on that first page show the Cranston property on both sides. The north side, which is not really at issue here, and the south side, which is shows the gap between the railings and the walkways on the Cranston property and the Kelly property from the beach side. The second page, I think, is even better. It shows the same area from the side away from the ocean, which is where the cars are. There's a road back there that's where the driveways are. So the inner of the house, from the right where the photograph is taken at the bottom of the second page.
Excuse me, Ken. Could we put that
Diagram back up.
diagram back up, please, to go along with the pictures? It would be helpful.
That's beyond my pay grade here.
Okay.
Thank you. So looking at the two photographs at the bottom of those two pages, what you see is a no man's land created between two houses, each of which have got a walkway adjacent to the house. The reason why they have a walkway adjacent to each house is because these houses are raised off the beach, off the ground, and the lots both slope pretty dramatically to the ocean. So as you enter the walkway on the, I'll call it the front of the house, where you enter from the street, the walkways are level with the dirt. You open the gate, you're just right level with the dirt. As you walk to the back of the house, the walkway raises as much as 6 feet. Thus, the problem with these lots in sloping to the beach and trying to get access from front to back, and an ordinance which was adopted some 30 years ago when houses were principally built on the beach, on the grade. So this is a problem which the prohibition on decks in the ordinance code basically mandates that houses be a long ways apart, and if they want to have a walkway, they have to have it, each one has to have it 3 feet away from the boundary. And for the life of me, I can't figure out why. I mean, I guess it was done 30 years ago when no one was asking to have a deck. There wasn't any particular reason, I guess, to have a deck along the side of the house, but it is imperative almost for the design of current houses. So if you understand the somewhat total irrationality of the ordinance as it relates to how you build houses on the beach today, with the new ordinances requiring them to be raised off the beach, you know, one of the principal reasons we're here today is because we've been unable to get the staff of this County of Ventura to support and to work on a change of the ordinance. So you are the problem solver that we came to talk to. However, that brings me to my main point today, which is frankly to ask for a continuance of this hearing on that point. And although we've been pending for a long time, we were sort of sidetracked from getting this issue of amending the ordinance before all the people that need to know about it, because just about the time when we got an email from the staff planner about potentially holding this hearing on the 13th of February, asking whether we could attend, we got a call from Steve Offerman's office, Steve Offerman, on behalf of Steve Bennett, who wanted to discuss this issue. We didn't ever responded to staff about the 13th hearing because we didn't know where it was going. Our alternative was to follow up with what I started 6 months ago, which was to meet the committee members in charge of government liaison with the county for the Frio Beach Homeowners Association, the Muscle Shoals Homeowners Association, the Seacliff Homeowners Association, the Solomore Association. Talked to all those people. They said, well, but if it's going to come to hearing, we want to know about it because it affects all of us. Well, I said, sure. Well, then when Steve Offerman's office called and wanted to discuss it, we said, great. We'd love to get somebody's attention to this subject because really what it is throwing some money at changing the ordinance. So on the 23rd of January, on the 16th of January, we got notice of this hearing saying it was scheduled, not saying whether we could attend, whether we were ready, but saying it was on your agenda. So then a couple days later, we get the call from Steve Offerman, and I went and saw him, along with Larry Graves, the architect. Explained the whole situation for 45 minutes, like we would do here with you today if we had to. And he said, well, let me talk to Steve Bennett. Got 5 days later, we get a phone call saying he's on vacation for 10 days. He wants to meet and confer about it. So we wait. So he does, and then where's my notes? On the 31st, we got a notice that he, was it 31st? Yeah. Oh, no. On the 6th, we got notice that he'd met with the planning director, and one of the issues we brought up was the fact that the local coastal ordinance is already being amended. And we couldn't understand why they couldn't piggyback this amendment onto that amendment, which is one of my main points about there's no real reason you can't do this now. And I heard about that from the other association committee members that knew there was an amendment in process. So when I brought that up, he met with Kim Prilhart. We heard that he was told that the amendment in process is through a grant, and it was for specific things, and this isn't it. So the money that was allocated to do that can't be used for this. And that there's no other money right now, there's no direction, and if we did get it on a list for priority for the county to be working on it, it would be 2 years. So that was a beginning of last week, and then I heard from Kim Prilhart on Wednesday of last week, and she explained that again to me because I really didn't understand why they couldn't, through the conversation with Offerman, why they couldn't do the ordinance amendment with the current one. I didn't actually speak with him, Larry Graves did. So she explained again that the reason why they couldn't piggyback it on the current amendment. And so I suggested a continuance. And she said, well, it's already been noticed, so you have to come to the meeting and ask for the continuance. This is why I'm here. But the real parties in interest that I'd like to continue it to provide an opportunity for them to participate are all those associations. I'd like to go to the board of directors of those and explain all this, not just the committee member who would then report what we said. So I suggested we do it on April 10th, 17th, or 24th. So basically any of your meetings in April, we'd like to be able to come and kind of spend a little more time on this subject. If we're sort of already done most of the hearing, but I really think there's, just keep it focused. This has become the standard way of building decks in the back of houses at the beach. There are, and I don't, not just the side of houses, but in the back of houses where there is a deck. They take the deck and put it over all the way to the boundary and put a fence between them. And there's literally, 100 of them. And if any of those people currently seek a zone change or a building permit, they need a zone clearance. To get a zone clearance, they have to have a finding there's no violations on the lot. Well, every one of those decks violate the prohibition on decks. Everywhere. And so all of the whole beach community is subject to having a notice of noncompliance filed when they ask for a zone clearance. And then they got to cut off 3 feet of their deck, which extends over to the property line. If it's on the side of the house, it might be providing access to their house on the side. There's no leeway in the code. It says it's just prohibited within 3 feet of the boundary, any deck. There's no definition of a deck, but I assume anything that's got air under it's a deck. But, which brings up a subject of design. We tried to get this to say, well, if it's got air under it, maybe we'll just build a wall and backfill it, put a sidewalk on top. Well, then they said, but you have a railing on top, now it's a wall, and it's over 6 feet, and you violate the wall ordinance. You can't have a wall or a fence over 6 feet. So consequently, you get that violates it too. So what we'd like is to have this hearing continued, and we'd like to be able to bring in some everybody that has an interest in being able to keep decks that have been built in the side yard setback and to design houses with a deck within 3 feet of the side yard setback. And by the way, it's not just the side yard setback. It's any boundary. So every deck that is out to the seawall would likewise violate this ordinance. So that would be my request. If it's not granted, then I'd like to have some more time to talk about these railings that are on the outside of the deck that are 3 feet over the property line, and the what we consider discriminatory enforcement of the ordinance with the issuance of approvals for decks, just like the Granston deck that was approved by mistake. Well, he's not the only one. There's decks all over the place that have been approved by mistake, and he feels very discriminated against that he can't do it when everybody else has. And the property owner next to him is planning a new house, and he's here, and he wants to build it with a deck that goes around the side so he can get access to ground level of the house from the front, and he's here too. So I just would like to get the continuance, and if not, then I'd like more time.
I have a question.
Okay, go ahead. Question, Commissioner Armstrong.
There was reference in the staff report that you had an opportunity to amend the project to conform to the coastal zoning ordinance. What amendments or what exceptions exist?
I don't know how you can do it. I don't know,
That's your response?
if we could comply, we would comply.
So you don't see a means of complying?
I don't. I really don't. On the there's basically nothing allowed in this 3-foot area that you see that no man's land between the houses, except a ground level sidewalk. So it's an enforced no man's land.
Okay, you indicate that the various homeowners associations up and down the coast all have the same problem?
Yes.
Okay, so we are talking about how many homes potentially?
Hundreds.
Hundreds.
And new ones have the biggest problem. I mean, if you've got an existing house that's built, on the sand, you wouldn't really have the problem, except that even those people have extended the decks in the back over to the property line so that their patio goes side to side. And if they were to comply, they'd have to cut off 3 feet of their deck and lower it to the sand, even if it's this much.
There's a great deal of conversation about the gap, okay, and staff takes the position the gap needs to exist because of structural, seismic, geological, and other reasons. Your thoughts on that?
We believe that the gap is required. We don't believe it's got to be 3 inches. We think it's got to be maybe a half an inch, which would be a perfect way to drain it anyway. And secondly, though, the purpose of this walkway, as it's currently designed with the railing remaining where it is to be able to put plants there, to be able to screen the underside so you don't look down at this gap area, to be able to prevent access from the street in the side yard, which is a security issue. So there's a variety of purposes besides walking on it.
I didn't really understand the play of the exclusive, non-exclusive easement, or how the easement comes into bearing on any of this.
It really doesn't, I don't think, because the purpose of this application is to build a deck in the side yard setback on the Kelly property, and whether that's all it's for. And whether it's on the easement or it's not on the easement, it doesn't really make any difference. Kelly's the applicant. Kelly is doing this because in the 30-year-old settlement agreement, there's a cooperation provision that he can't interfere with the use of the easement by the party that acquired it. He's obligated to cooperate, so he's cooperating and saying if it's legal, it's okay. It's not legal, not okay. But in terms of whether even if we did a lot line adjustment and Cranston bought the property where the easement is, it still would have the same problem. You can't put a deck in the 3-foot setback on either property.
Go ahead, Nora.
Commissioner Dukas.
I just want to be clear again, what exactly is the project that's before us? Because, I hear what you're asking for in terms of what you want to accomplish with this continuance, but what is actually before us today? Am I correct in that it's not to amend the coastal zoning ordinance or any of the guidelines?
Commissioner Chair, Commissioner Dukas, that is correct. We did not notice for a coastal zoning ordinance text amendment. And we do have a rebuttal to a number of the points that Mr. High raised, but we'll let them finish and we'll take those up at the end, if that's okay with all of you.
But what I'm hearing is that you'd like more time in order to present more evidence and have more people give evidence on this matter.
Yes.
But that's not what's before us today.
Well, the code provides for the ability to amend the code by the Board of Supervisors doing it and by an individual applying.
But you
And it
understand,
also provides for the the Planning Commission to make a recommendation to the board. I don't know how we get before you for that purpose if it isn't here and now with this situation. If needs to be an application filed to ask you to do that, we can do that and have it brought the same day as this. My idea was if you agreed with the people that support an amendment, we could continue this matter, for which a filing fee has already been paid and processed, and all the plans have been looked at and everything else, until that was completed. And then the only real objection to this, in terms of violation of the code, would be done away with, and we could be brought back here without this issue of the zone, of the prohibition in the code being an impediment. And quite frankly, I talked with Kim Pirhot on last Wednesday about the private application to do that and the continuation of this until that was completed. I haven't completed a discussion with her on the fees and costs, but I do know that since that phone call, we got an email, or Larry Graves got an email from staff saying that the filing fee as a deposit was $7,000, and that's a start for a private individual to process the zone change, or it's not a zone change, it's a code change. So therein lay the problem of bearing the burden of doing this. And so, yes, my goal in this is bring in the parties that have an interest, convince you to support an amendment to the code, and take that to the board and have them say, yes, it's important, we want to do it. Then continue this matter until that's over with, so that the filing fees aren't wasted, we don't have to go back and do it again. And then the impediment to granting this application can be done away with.
Commissioner Dukas.
is there a way to get what he wants? Can we get from here to there, County Council, with the matter that's before us?
Yes, your commission could continue the matter that's before you if you think that it would make sense to basically put this specific project on hold for however long it might take to amend the coastal ordinance, which could be years. But if that's the direction that you want to go, that it's within your discretion to do that. So I think that it's within your discretion is the short answer.
Are you saying that if an application was filed today, it could be years before it could be evaluated and approved or disapproved?
That sounds like that's in terms of the coastal, the change to the coastal zoning ordinance.
Let me comment on that. I talked to Kim Pirhart about it. If a private application is filed, which we haven't ruled out, and frankly, I just got the deposit amount and stuff, so we'd like to consider that again. But if that's filed, then it takes priority over all of those other things. It's like an application for this permit. So it can be done expeditiously if the staff it takes it on, and it's not behind 2 years' worth of other projects. Unfortunately, if you recommended to the board that they change the ordinance, then she said she would go to the board and say the same thing she said to me and to Steve Bennett, which is, which projects don't you want me to do? I've already got 2 years' worth of projects with current staffing, so it's going to be years. Which is why we were then, having heard that last Wednesday, more seriously considering the filing of the application for the change of the code ourselves, so we can get it done. Again, another reason to continue this, so we could at least get that started.
Is there not a possibility of having the other homeowners associations join in on this fee and the cost?
Yeah, but I haven't asked them yet.
No, I understand that.
Absolutely. And incidentally, I've got another hat on here. I'm the president of the Muscle Shoals, the Homeowners Association. It's not all of Muscle Shoals. It's actually the part north of the pier called Breakers Way Association. It's about 30 members. And of its constituents, we've got a whole bunch of interested parties, none of whom know about this yet. All of whom have got either decks that are a problem or decks they'd like to build. And that's just a small one compared to the other associations with many more people.
Other questions?
And again, just between us, I can't for the life of me come up with any particular good reason why it was prohibited in the first place, much less in 2014.
Commissioner Westman.
Mr. Chair, before we proceed, I think we need to deal with the issue of continuance, but I heard staff say they had some comments that
on
might
the
weigh
bottom.
in on that as far as my decision whether or not to agree to a continuance.
I still have 2 speaker cards. We'll hold those in abeyance pending staff's comments and further discussion by the commission.
Thank you, Chair Rodriguez. Just a few points. I just wanted to clarify that the Planning Department is not recommending that we take away the raised concrete deck that we erroneously approved back in 2008. We are just recommending, we have denied and we're recommending that your commission uphold the denial of the Kelly's newest approval to add a deck on their side of the property. Also, the definition, how we reached that this was defined as a deck, it was outlined in the Planning Director staff report that was included in your packet. I just want to read this portion because I think it helps to understand why we are referring to this as a deck. The concrete cap with wing supports does not meet the definition of a fence, which is defined in Coastal Zoning Ordinance Section 8172.1 as any type of fence, wall, hedge, or thick growth of shrubs used as screens, but not including windbreaks for the protection of orchards and crops. Based on its design and location, the proposed project consists of the construction of and functions as a cantilever deck and meets the definition of a structure, which is defined in the ordinance as anything constructed or erected on the ground or that requires location on the ground or is attached to something having a location on or in the ground. So that's how we reached the conclusion that this is a structure, hence a deck. Also wanted to reiterate that the project before the Planning Commission is a request for a minor modification to PD 1016. It's not for the text amendment. And to notify your commission that the appellant has been made aware of the process to apply for a text amendment. Our staff has met with Mr. Larry Graves over a month ago to give him the application and the filing fees, and Mr. Hyde did state that he is also aware of that process. So that's all I had. Mr. Clement might have some points to add.
Other staff comments?
Do you have any questions of Ms. Deanna first? Or?
Yeah.
I do want to explain the amendment process and where we are with the local coastal program amendments that we're currently processing, and why we can't just tack on this amendment to that process. As you're well aware, the coastal zoning ordinance amendment process is very involved. It not only goes through the county process of approval, but then goes on the Coastal Commission. There's a lot of work that's involved, takes a lot of staff time, a lot of resources, a lot of money. Okay, we do not have funding right now to process this particular amendment, but what we have made clear is that, once again, they could file for a privately initiated amendment, and we have spoken with Supervisor Bennett's office about how this could be applied more broadly to not only encompass this project, but also all of the neighbors where these problems exist. As you know, what happens is when we're trying to establish the priorities of these amendments, that is which one we're going to process, because we have a long list of things to do that have been established by the Board of Supervisors. Every year, the long-range planning section is required to go to the Board of Supervisors, inform them, okay, these were all of the requests of amendments that you've requested us to process in the past. This is our current funding, this is current staffing. Which ones are priority for you, and which ones should we process first? And the board establishes our priorities for amendments. They can very well, the appellants can very well lobby the board and get the board to take the position that this is a priority situation and bump it up in our list of priorities. But right now, given our workload, that's not the case. With regard to the local coastal program amendment that we're currently processing, that is partially funded with grants. and there are strict deadlines by which we must achieve certain milestones. So if we compromise those milestones, we're going to compromise the funding in order to finish what we already have on our plate. That is why we can't tack on additional amendments. And trust me, there have been a number of requests to tack on additional amendments, and we've done our best to accommodate as many as possible. And it's already grown to something much larger than we originally began with, but we have to cut it off at some point, and we don't want to compromise what we've achieved so far. So I want to explain that. With regard to the decks that exist, not only in the Muscle Shoals area, but in the other neighborhoods which are within the setbacks, as you're aware, our enforcement program is a reactive program. Somebody goes out, files a complaint about a deck, we will have to go out and enforce it. There have been changes in the codes over the years. There have been changes in interpretations of the codes over the years, which have allowed these. Some of these decks have just been flat out built illegally. But we're not going to go after people because we observe it, we respond to violations. So we do have cases. In fact, there's one right now which is the product of a complaint where somebody built a deck in the side yard setback, and there's no relief afforded in the ordinance to them. And on that point, I want to make it explicitly clear. We have discussed this issue with Mr. Offerman. We have considered amending this section. We think it's very reasonable, especially given the fact that right now the Coastal Commission staff has published these draft policies regarding sea level rise, which will have an effect on how we evaluate projects which are built adjacent to the coastline. So it's a ripe time to take a look at this section of the code and see whether or not it makes sense and what adjustments we need to be made to the code, given the fact that the buildings do need to be built up higher than they historically have been in order to get them out of the flood area. So it's timely, but once again, we don't have the staff or resources. We'd be more than welcome to take this on, but we just don't have the capacity right now to do it. We're in full support of this, and I do believe it's a mischaracterization to say that we have been dismissive of this. The planning director has met with the appellants and has done as much as she can to interpret the code in order to allow this. She has just come to the conclusion that she cannot make any more exceptions given the current language of the code. She's only allowed to interpret where there's something that's unclear in the code. These regulations regarding what exceptions are allowed to the setbacks such that you can build in these areas, it's very clear, and it affords her very little discretion to interpret it than any other way than how it states in black and white.
Mr. Chair?
I'm
Yes,
sorry.
Commissioner Wesson. Do this? I'm sorry. Commissioner May.
Could this initial code, how it was laid out, would that be about public access to the beach?
That's a consideration. However, the setbacks are not for the purpose of establishing public access to the beach. It's more for orderly planned development, and that's a standard zoning practice, except for in urban areas where you have buildings built up to one another. But in areas where you have single-family dwellings that are detached, you try to allow space in between for privacy, other uses in that area, and things of that nature. So the setbacks really are not intended to provide for public access, but as you know, whenever we're looking at a project, we always have to take into consideration public access requirements of the Coastal Act. So, but it's really not related. So.
Thanks.
I have a question. Is there any opposition from staff for the motion to continue?
We don't see the need for the continuance because of two reasons. One, if you're going to proceed with the privately initiated amendment, file the privately initiated amendment. If you are going to lobby to try to have the board establish this as a priority and direct us and give us the money to go ahead and amend the code, go ahead and do that. But this appeal, if you feel you're going to be successful with this appeal, let's finish it right now. Because if you're successful, then you don't need the amendment for this particular project. Are you following me?
Yes, I follow you. Catch 22.
Mr. Chair,
Commissioner Weston.
so what I'm understanding, if for the appellant, since I haven't heard from the applicant, for us to uphold the appeal, we'd have to have some kind of overriding considerations based on what staff has laid out or the reasons why we need to deny it. So my concern is I don't know if I have enough information right now to make those kind of overriding considerations, particularly in view of hundreds of other people. So the precedent-setting issue I'm a little concerned about. So that's one of the reasons why I'm in favor of continuing. I don't know how the rest of my commissioners feel about that. In other words, I don't think I have enough information right now.
So if if this matter was continued or placed in abeyance, it would be pending. Mr. High would have the opportunity to speak to the other, homeowners associations, and see if he can put a group together to fund the application, spread that cost over multiple people, and let it play out. I agree. If hundreds of people were involved, I would like to see the process of an amendment or a proposal to make an amendment vetted.
I'm not in support of the continuance. I'd like to go ahead with just what is before us. I haven't seen any evidence that hundreds of people, other than this man's word, that hundreds of other people are interested in amending the coastal ordinance, and I'm not comfortable that I have enough information that I think it's even a good idea to have side decks on the property. So I'm not in support of the continuance at all. I want to hear the matter that's directly before us.
Commissioner Maggie?
I'm not sure what adding hundreds of people are going to do in terms of the value and the thought process on this change in the coastal zoning ordinance. I tend to agree with what your premise is, but I don't believe this is the place to do it. We're not going to change the coastal zoning ordinance here. And we have a matter before us that we can deliberate on. And if, it seems to me the only option for the Pellin is to do the private thing. Well, they're going to meet with all the folks anyway and take care of that. I just don't see where we're part of that.
It is a catch-22 situation. I'm really torn here. I don't doubt Mr. Hyde's representations that there are probably hundreds of other residences out there along the beach with similar violations. As coasting, an ordinance change would, in essence, legitimize all this work that's been done, that occurred. And I understand where planning is at and the limitations that we're working within and the foundation of the recommendation. I'm curious. The only thing if a continuance occurs, I'm troubled with what we expect to happen then, that we can count on with some reasonable assurance that will occur. Otherwise, we go forward with what we have here.
Continue it to a time certain.
I know you haven't closed the public hearing, so I just like to make one comment.
We haven't heard from you.
If you're going to take action and deny this, as staff would like you to do, then fine, we're going to need to go to the Board of Supervisors. But I'd like to go to the Board of Supervisors with a recommendation from the Planning Commission that this issue be studied and a change of the local coastal plan in this regard be initiated by staff. That would give legitimacy to our request to the board to do that. It would give some support that you've thought about it and you think it's a good idea to at least study it. And then when we go to them, we can ask them to put it up in the priorities and take care of this problem. Otherwise, if you deny it today, we go up to the board and there's no comment about it whatsoever, other than we could get the comments by Dan Clayman that just said that he thought it was a good time to do the study and it was a reasonable request to do. So that is helpful. But so what I was trying to accomplish was to get you to make the resolution of intent, I think they called it, to change the local coastal ordinance. And that's what I was going to try to get further support to you from other interested parties to get you to do that. Whether that results in an approval of this or not, I don't know. And then my second thing I had to stand up here for, if you're going to take action today or even later. I can make this comment and not have to do it again later. I think if you do nothing else, I think you can approve a minor site plan adjustment to allow the railing to stay on the outside of the raised deck. I can't find a specific prohibition in the code for that. Staff says that it's a violation, but I don't know what it's a violation of. It's not a wall or a fence because there's nothing under it. It's not a deck because the deck is on the Cranston property. It is a post hanging in the air over the property line by 3 inches. So I don't understand why the site plan for Kelly can't include the ability to have a post hang in the air right on their boundary. And then Cranston doesn't have to spend $15,000 recoring his deck to move those posts 3 inches. And that's where I was coming from with that subject. Simple solution to a problem. Thank you.
Question, County Council. If the commission moves forward, makes a decision today, we have the ability to make comments or recommendation to the board with regards to our action if it's appealed. With recommendation to dealing with modification of the ordinance, their consideration.
Yes, your commission could make recommendations to the board that the board could hear. It sounds like what you're asking, yes, the short answer is yes, you could. And it's difficult right now because the way the coastal zoning ordinance is drafted, it does contemplate a process where the planning commission initiates an amendment. But as we've heard today, there's no amendment that is before you, and so it would be too preliminary, in my opinion, for your commission to actually issue the resolution of intention that's referenced in the ordinance. My belief is that process contemplates an amendment already having been developed, and so that hasn't even occurred yet. And so, but it would definitely be within your discretion to take whatever action you're going to take today with regard to the specific project, and then when the matter goes to the board, make recommendations in terms of an amendment if that's what you so choose. And at this stage, it would be a recommendation having to do with studying the issue, basically, because there is no amendment that has been developed yet.
Okay, thank you. Further discussion?
It's in your hands. We've got 2 for continuance.
Well, I'm not through yet. So if we continue the matter and this project, they've got their application fees out there, then I assume, well, let me back up. It would appear to me that there's a violation of the setback requirements, period, under the current zoning ordinance, okay? That's fairly clear, whether you like the ordinance or not. But it also seems to me, given the fact that there are potentially hundreds of people involved, and staff themselves say the issue is ripe, that at the very least we should make a recommendation to the board that they study the issue, at the very least. It probably would be helpful if you had an application on file. I'm sure you think so too.
Just afraid of the potential $20,000 fee.
I understand. So I guess in continuing the matter and the application pending, I'm trying to save them some money, potentially. It may or may not. But at the very least, I would move that we make a recommendation to the board that this matter be given some priority.
Commissioner Chair, I'm sorry. I just want to make sure we're doing things procedurally correct, because we have a hearing that we started. You haven't heard all of the testimony from everybody who's here who has requested to speak. It seems like, I don't know, and I'm looking at county council, I really don't know the answer to this, but it would seem like you would want to hear all the testimony first, then make your decision to continue. I don't know.
Is it within the Planning Commission's purview to consider costs, anything financial? Is it something that we have the power to aid us in our decision-making, how much things cost?
I can't sit up here and not consider costs. I think it's ridiculous not to consider the costs that these people are going through.
We've been in other situations where the financial impact, the economic impact of a project is not within our purview. Am I correct?
I think it could be. I mean, it is in your purview, and I don't want to limit your discretion in any way. I think it could be relevant, but I should clarify, and this goes to Mr. Clemens' comment on the process. If your commission does grant a continuance, then the matter before you today, in all likelihood, will not be going to the board. And so I just want to make sure you understand that, because there will be nothing to be appealed to the board, basically.
Correct.
And so we're talking about making recommendations to the board to study this potential amendment. Excuse me, but if you continue the matter today, nothing's going to the board. And so if you would...
Not even the recommendation, if we make one?
I think procedurally, the proper step there would be to direct staff to bring that type of item back before your commission as a Brown Act noticed item, and then proceed that way, because the only item that's been noticed for today is the subject project, and not an amendment or a study session regarding amendment to the coastal zoning ordinance.
Thank you.
It's like
We
pouring water on
still
the
have
stone.
2 speaker cards. This is a public hearing. I need to let these speakers,
Yes.
give them the opportunity to come forward. John Kelly.
Good morning, Chairman and Council, or
Whatever.
District members, Commission members, excuse me. My name is John Kelly. I am co-owner with my sister Nancy Caldwell of the property located at 6766 Breakers Way. The application before you lists our mother Gloria Kelly as owner. For the record, I would like to inform the Ventura County Planning Commission that our mother passed away on October 9th, 2013. Nancy and I are now the new owners. This permit application lists our mother Gloria as the applicant. However, our neighbor, Mr. Cranston of 6768 Breakers Way, is the one for who this application has been submitted, and he is the appellant as well. 27 years ago, the then owners of the Cranston property sued our parents over an alleged case of adverse possession. The settlement agreement that was reached gave the neighbor easement rights to use the 5-foot strip of land between the 2 homes, while my parents maintained their ownership of the land and the obligation to pay the annual property taxes. After the sale of a neighboring home a few years ago, per the settlement agreement, the right to use the land then passed on to the new owner, Mr. Cranston, who, while building a new home on his site, planned to extend his deck and railing onto the easement area. Due to the terms of the settlement agreement, our mother was required to apply for this permit on Mr. Cranston's behalf, as she was the legal owner of the property. Mr. Cranston has paid all the fees and expenses pertaining to this application and appeal. Nancy and I neither oppose nor endorse the permit before you. We are required to abide by the terms of the settlement agreement our parents signed with the previous owners many years ago. Our concern is that the proposed structure is compliant with the Ventura Building and Safety Codes as they exist today. As the owner of this property, we look to this commission to ensure that this permit meets the necessary requirements for the safe and legal use of our land by our neighbor. Additionally, I would like to note that I am the sole spokesperson for my family today. Neither Mr. Graves nor Mr. High is our representative. Mr. Cranston has hired them, and they speak for themselves and him only. We thank this commission for its careful consideration of this permit application appeal, and we look forward to your decision and to the conclusion of this lengthy process. Thank you.
Thank you. Comments, questions, Mr.?
I'm so sorry for your loss.
Thank you very much.
Thank you.
Mr. Kelly?
Yes.
Mr. Chair. So you support that this appeal be approved? Is that my understanding?
The appeal, I cannot I cannot, because of the legal requirements, I cannot support or deny this. I mean,
Okay. Got it. Thank you.
so I have to remain neutral. I'm sorry.
And I have a card from Steve Bennett.
Good morning. I'm
morning.
the other Steve Bennett. I'm the next-door neighbor on the north side of the property to Mr. Cranston's property. I have 2 buildable lots there, and I intend to build 2 houses there in the next 5 years. So this is a very, this is a very concerning issue to me. My history here is that my grandfather built our existing house in 1947, and I spent my entire life, even as a kid, painting it and repairing it and watching as the ocean changed and the elevation of the ocean rise. One of the big issues here that hasn't been discussed is about this elevation change that they're requiring. The flood control department has required these foundations of these houses to be raised, which is good because we're dealing with a rising ocean. The problem with this whole issue of this 3-foot setback in these side lots is that you're creating a channel through which the ocean can go through all the way to the street, and it's very destructive. And I've been through all of the ocean disturbances that we've had for the history of the house since I was born in '55. And I have photographs and everything to show that. This is a very big issue, and every single property on the ocean in Ventura County and in the entire coast of California is having to deal with this. So I actually had approached the supervisor's offices back when Kelly Long was the supervisor here. And we had discussions about this. I even met with some of the heads of the departments to talk about these changes that were coming. And we're talking a long time ago, many, many years. So we're kind of getting in the tail end of this whole thing right now. We're way behind the 8 ball. I've watched the ocean just recently. We haven't had an occurrence for several years now. The last time we were hit, I had waves over the top of my house that hit the street. That's how bad it is. So when they're enforcing this issue of not building within the 3-foot setbacks, they're creating this channel where the ocean can go through there and be very destructive. And that's another reason why construction like this, where you've raised the height of the walls and you allow the construction to go to the edge of the properties, actually allows the next door neighbor, or should allow the next door neighbor, to build another, right next to it, and continue that line down the houses. Otherwise, you're creating a problem with the neighbor next door. And that's unfortunately what's existing for me right now. Brian Cranston's property, erroneously, as was stated by staff, was allowed to build a raised deck with foundations underneath it against the property line on my side of his property. But I'm not going to be allowed to do that. So when I go to build, I have to have a 3-foot setback, and what they're enforcing right now is this lower elevation, which creates a channel for the ocean to go through. And I can't conscientiously do that. That's crazy. It undermines my property. It undermines the street in front of us. It creates it creates a lot of problems. So I really would like to encourage allowing the process, or for you to support going before the supervisors and recommending that they look at how to change this ordinance, because it's I don't know, it's really hard for me to fathom that it's still in existence, that we're not allowed to build there. And the truth is that every house, as Mr. High has stated, I've driven all over the county, and I've also done construction in the county. And I've gone up and down the coastline here and looked at properties all up and down the coastline. And there's very few properties that don't build an elevated walkway or deck within 3 feet of they build right up to their property line. Because as you well know, all these properties are worth a great deal of money, and every square inch that you can use on the property has to be utilized for what you're paying for the property itself. And anyway, so I don't know how to recommend on this particular issue right now. I mean, I would like to see you support it, but I also understand it's not legal under existing ordinances, so that puts you in a really tough spot. But I personally think that they should be allowed to go ahead and use it. You've got neighbors that are not opposing it and have agreed on using that area for that purpose, so why not allow it? Except for the fact that it's not legal. And so I don't know, I can't address that legally, but I can tell you it's going to be a problem for me when I go to build. I'm in the preliminary stages right now to start looking at permits for my 2 properties, And I don't even know how to approach this right now. I don't know how I'm going to go and get foundation plans drawn or anything when I don't even know where I can build to, except by these requirements. And I just can't even conscientiously see, I have 2 lots. When I build 2 houses, I'm going to have a 6-foot gap between my houses, and they want to have existing elevations down there, and I can't conscientiously do that. It doesn't make any sense at all. I have to build and protect the front of the property with the front of the house and the foundation on there. So it's put me in a real bind. So, and I agree with Ken High. I think this affects millions and millions of dollars worth of properties in this county and hundreds of homeowners. So I would really like to encourage you to support looking at getting a change in the ordinance. And any other history, or I'd love to have brought photographs up to you to show you how this affects the ocean going through there. But anyway, we can, as we go through this process of trying to get an amendment made here, we can present that kind of information. And I thank you for your time. Thank you very much. And any questions?
So,
Questions, Commissioner Onstock?
I grew up going to the beach, Berea, etc. I never thought that a common seawall running up and down the coast was illegal, but that you're telling me it is, isn't it? The seawall. Did there have to be setback? I'm talking about the ocean-facing seawall that are built up and down the coast.
No, those are legal. They have
Okay.
planned development permits for those.
Okay.
I can't vouch that everything was constructed in accordance
Right.
with permits, but no, you have to get a permit to construct a seawall. Yeah.
Okay, and,
So
and over the years, the people, I guess, who didn't hauled in the rocks in violation of coastal ordinances and what have you? Okay.
My particular seawalls are actually permitted by the county, and I went through and had engineering done on them, including Mr. Cranston's seawall. The bind that we're in right now with the Coastal Commission is not the county has said that the wall should be 3.5 feet higher than what I have right now, but the Coastal Commission won't allow us to have permits to raise the walls. So now it's true. That's exactly what's going on. I can't raise my walls legally. They won't allow me to put rocks in there and raise it up to what the county ordinance requires. So we're in a real catch-22 with that also. So that becomes less of a first defense. I have some seawall protection there, which is a first defense, but the waves are coming right over the top of those walls. So the second defense is actually the foundations of the house itself, which is why Mr. Cranston's house has got a massive cement front there, and that was part of my recommendation to him because of how strong the force of the waves are to come up there. But it's a real 8-ball for all of us property owners to deal with.
Commissioner Dukas?
am I to understand that in these high storm events, water comes up and up to that little street?
Yes, I have had it go up to the street I have kind of let me back up. I have 2 lots. I have a single house built over the property lines on those 2 lots.
Is it on our photo?
Actually, it's on one of the aerial photos there.
Can we get
Might
it up?
show it. Sorry, Michelle, do you have it? There you go. Do you have a pointer? That's okay. The Kelly's property has got the slotted lines that are running around it, and then just up from that is Brian Cranston's house. Then there's kind of an empty lot. You can see it's kind of an empty lot to the next roof line. So that's that. I have an empty lot, basically. It's not a full-size lot, but I have an empty lot between my Cranston's house and my house. And I had the ocean go through that empty lot all the way up onto the street. I even have a fence that is up on the street side of that property, and that fence got knocked down by a wave. So, yes, the waves do go for that far.
Is it a regular occurrence?
No, it's not, which is kind of unfortunate.
Does it?
In the sense that we all get kind of complacent about protecting these properties.
But, I have very vivid memories of Faria Beach just being utterly destroyed by high waves, and that
Yes.
wasn't that long ago. And my recollection, being born and raised in Southern California, is that there are these severe storm events. But what you're saying is during like high tides and during storms that you get channeling through the properties?
No, we only have that channel when we have those major incidences like we had at Faria. That's when we have the waves coming up over the houses.
Uh-huh.
and heating the front of the house.
But I was listening intently to what you were saying with houses, with water coming between this no man's land. Does that occur?
Yes.
Okay. So it's a health and safety issue. Okay. Thank you.
Yeah. Any other questions? No. Thank you very much.
Obviously, the code needs amendment. I think everybody's in agreement there. Trying to understand how we can most expeditiously move forward on, realizing that's not in front of us today. If I need some
Mr. Chair,
some input.
as I said earlier, my concern is, since this is a de novo hearing where we're allowed to hear new evidence and argument, and we also can approve, deny, or approve modifications. I've heard testimony as far as the matter in front of us that they may be able to provide, if we continue this, additional information. If I'm to find any kind of finding or fact that I can rely on to either modify or uphold the appeal. And that's my concern, is I'm denying the appellant, and I don't hear any opposition from anybody else, the opportunity to present me new arguments and new evidence to deal with what's in front of me, particularly in the area of any potential modifications that we might be able to suggest. So that's one of the reasons I'm supporting a continuance is nobody's opposing it as far as the landowner or the property owner or the appellant, which is their right. So nobody's being denied a due process. But I'm sitting here with questions in my mind is there a middle ground given the current status of the law?
Well, and I would disagree with you that you don't have an opponent. You have someone who has certain obligations per a settlement agreement. That's not the same as not being an opponent. They just have to fulfill their obligations with that settlement agreement.
But again, I'm hearing testimony that there may be something as far as the matter in front of me that may be provided by the appellant if given the additional time. I don't see anybody's due process being harmed by allowing that, given the uniqueness of this situation. So that's what I'm sitting here going, I don't have enough information to go one way or the other on the matter in front of me. And maybe there is something that the appellant can sit with staff as far as the 3-inch and the 1-inch and whether it's a fence or not a fence, to the clarity of my mind. And that's what I'm looking at.
I'll just make your motion, we'll see if it flies.
Well, is there anybody, I guess the public, is there anybody else wants to talk? It's just we're doing it.
Any other comments, staff or public? Staff?
Yeah, I apologize for coming back here. Anyway, there was some discussion, just for purposes of the record. My name is Brian Baca. I'm a certified engineering geologist, certified hydrogeologist, and a professional geologist licensed in the state of California. And I also handled all the coastal permits for 17 years for Santa Barbara County. And I can tell you that it's not a simple thing to say that if we blocked off the area between the buildings, that would decrease hazards. Actually, it would increase hazards, and it would cause liability by changing the level of floodwaters to where if you put something between two buildings, that might raise the level of coastal flooding for the adjacent properties, not just the two that are at that one point, but the ones that are adjacent. So it's a very complex thing when you start obstructing floodwaters. And it'd be the same along a river. When you're obstructing floodwaters, that has an effect on other properties that are not necessarily the site of the obstruction. And so, in general, the idea of coastal development is that you don't do anything to change and increase the flooding on other people by your construction. And also, you have your building elevated to the point where the water doesn't go inside the floor of the building under the design flood. So it's just not a simple thing, and really, if your commission wants to have some technical testimony from the people who really know the Watershed Protection District Flood Control Section, they review and analyze these kind of coastal things on a regular basis. So I just want to point out that if you want testimony in that regard, you really should talk to Mr. Chuzinski's group and the engineers who work for the county as to what exactly happens with flood control issues at the coast.
And Commissioner Chair, just to tack on, those are precisely the types of issues that need to be evaluated as a part of a coastal zoning ordinance amendments, because you pull on that string and the whole ball falls apart, because it's not simple, just go ahead and change the code, allow the decks and the setback, and you're good to go, and everybody's able to build. There's a lot of considerations that go into a coastal zoning ordinance amendment. So, and once again, when this proposal was presented to the planning director, the planning managers all discussed it, we said, makes sense. However, we need to evaluate it further, and that's precisely what you do when you go through the legislative process. So,
Further comments from the commission? Do I have a motion?
Mr. Chair, I'd like to make a motion to continue this to a date certain in April per the request of the appellant to allow them their proper due process under our de novo hearing for any additional evidence or argument. Thank you.
Second the motion.
A motion and a second. And vote. We have a motion to continue. It's passed 3-2.
We need to get a date from the clerk.
Exactly. We need to get a, set up a date, time certain, to reconvene this hearing. Do I have any, there have been some dates mentioned, April 10th, 17th, 24th. Staff have a comment? What do we have in the calendar?
it looks like either of those dates will work. We're checking right now. Ms. Deanna did have a good comment. She was asking whether or not there's anything specific that you would like staff to research and be prepared to discuss when we reconvene for.
Mr. Chair, based on my comments, is I've heard enough comments about potential modifications, which is one of the powers that we have, and a discussion or representations. I'd like to have some certainty coming back that either A, the staff cannot agree with what proposed modifications and or whatever the appellant is proposing is capable. So again, I would rely on that technical expertise. And if the answer is no, the answer is no, and then both sides will have an understanding. Then I'll be capable of making a decision.
And to clarify, you mean modifications to the project in order so that it could be approved?
I will leave that in the delicate hands of the appellant and staff.
Gotcha.
Pick a date.
How does, what does the 17th look like on your calendar, Lori? Oh, I'm sorry.
We don't have availability confirmed for the planning commissioners for the dates in April. We do know the planning director will be here on April 3rd and April 17th.
17th is good for me.
Good for me.
17th is good for me.
Okay.
I think it's important that we all be here.
Well, now we have you all on tape that you'll be here on the 17th, so that's good for us too.
2014, right?
Yeah.
I don't have the planning commissioner schedule in front of me. Do you have that, Lori? The 17th, April 17th is the second Thursday or the third Thursday of the month. Is that a scheduled hearing date?
They're all Thursdays are supposed to be made available.
Right.
But do we have the?
I have a calendar that's already
Oh.
scheduled
Yeah.
that day on the 17th.
Yeah.
On the tentative schedule, if there's something on the 17th, it's in your folder, there'll be.
Well, they're doing that. I do remember the director asking us to keep the first and third Thursdays available.
Right.
Right.
There is one item on the agenda for April 17th that's already coming before your commission.
Okay.
Okay, so that'll work. Okay. We'll continue this matter then until April 17th, 8:30.
Notice waived, Counselor?
Yes, sir.
Okay, we can continue then with the agenda. Discussion items, staff?
I'm sorry. So I'm Tricia Meyer, just for the record. I don't think I mentioned that yet. I'm filling in for Kim Poolhart today. I don't have any reports on board actions that were recent, but you did receive a memo from Shelley Sussman, the project manager for the Saticoy Area Plan update, which went over some details for you on the proposed Planning Commission workshop to review the status of the draft Saticoy Area Plan. So as you can see on your memo, there's a tour planned, there will be a staff presentation, it'll be a full day of activities. Yes, so beginning at 8:30 and then here in this room, and then going on with the Saticoy bus tour for 2.5 hours, and then coming back for a brief lunch, and I believe we're going to be sending some menus out to you shortly from Panera, so you can choose your lunch items. And then the staff presentation, public testimony, and Planning Commission deliberations will begin at 1 o'clock, and they're expecting that to last 4 to 5 hours. So,
4 to 5 hours.
Okay.
Yes.
Thank you. Anything else from commissioners?
Mr. Chair, have we had any interest from the public to go along with this on the bus tour?
you know, I don't know the answer to that. I'm not sure that this has been sent out yet to the public.
Okay. All right. Thank you.
Okay. That concludes the agenda. Meeting's adjourned.